You know that feeling when you check the mail and there is a thick, official-looking envelope just waiting for you?
Oh, yeah. The absolute worst.
Right. Your stomach immediately drops, the heart rate spikes. Because, I mean, we view the legal and financial systems as this massive, heavy machinery that can just kind of crush us if we get caught in it.
Yeah, it's incredibly intimidating for most people.
Exactly. But in a 2-hour workshop transcript we are diving into today, which is titled Honor with Equity, a presenter named Julian Swan argues that that thick envelope isn't a threat at all. He says it's actually just a math problem waiting to be balanced.
Which is just a complete paradigm shift, honestly.
Mhm.
The source material we're looking at today outlines this highly specific, very intricate strategy for essentially stepping outside conventional legal and financial structure.
Completely outside them.
Right. We are talking about a framework that claims you can discharge massive debts, dismiss court cases, and just bypass standard regulations by using what Swan calls post-1933 equity. And, we really should set the parameters of this deep dive right up front.
Yeah, definitely.
Our goal here is not to endorse these claims as legal advice, nor are we here to, debunk them or call them crazy. We are simply going to impartially unpack the logic, the historical interpretations, and the underlying philosophy that powers this really unique subculture.
And we really need to understand that underlying logic because the stakes Swan lays out are just incredibly high. I mean, he makes this bold claim right at the very beginning of the workshop. He says that if you use the specific method of equity properly and you do not mix it with other legal strategies, it has a 100% success rate.
Wow, 100%.
Yeah, 100% success rate in keeping you completely untouched by the legal matrix.
Well, to even begin to understand how someone arrives at that kind of astronomical claim, we have to look at how this system redefines the fundamental nature of money itself.
Right, because it all starts with money.
Exactly. The entire framework rests on a very specific interpretation of the 1933 banking crisis. According to the workshop, in 1933, the United States and effectively the entire Western world went bankrupt. They moved away from currency backed by physical assets, so lawful money like gold and silver. And they transitioned entirely to fiat money, or what the source refers to as negotiable instruments.
Okay, so we went off the gold standard. I mean, most people know that happened.
Sure.
But Swan is arguing that this wasn't just like an economic policy shift. He's saying it fundamentally altered the physics of the law itself, right?
Yeah.
Because there is no lawful money in circulation, he claims it is mathematically and legally impossible to actually pay for anything.
Yes. That is the absolute crux of the entire worldview here. In this system, you cannot pay a debt with another debt.
Wait, explain that. How is cash a debt?
Well, Swan points to the actual piece of paper in your wallet. A dollar bill literally says Federal Reserve Note right on the top of it.
Right, it does.
And if you look up the word note in a financial or legal dictionary, it is defined as evidence of a debt. So think about it. If I owe you $50 and I hand you a $50 bill.
I haven't actually been paid.
Exactly. You haven't extinguished the debt. I've just handed you an IOU from the government. The debt was just moved from my ledger to yours.
I'm struggling with this jump, though. I mean, if I can't lawfully pay for anything, how does society even function? I still have to buy groceries. The government still demands my taxes.
Well, the source claims that because the government removed the ability to pay with lawful money, they had to provide a hidden legal remedy to the public, to avoid operating unconstitutionally.
A hidden remedy.
Right. If you can't actually pay a debt, the remedy is that the debt must be discharged, dollar for dollar. And this is done through accounting and what they call set-offs.
I want to pause on that term for a second.
Right.
What is the actual mechanic of a set-off in this context?
So think of a set-off like this. Let's say I owe you $100 for a concert ticket, but you owe me $100 because I bought our dinners last week.
Okay.
We don't need to physically hand a $100 bill back and forth to settle up, right? We just agree to cross it out on our mental ledger. The debts cancel each other out. Swan's argument is that since the government holds the ultimate collateral of the country, they essentially owe the citizens. Therefore, any bill or charge you receive can be set off against that underlying credit. It's purely an accounting mechanism.
Okay, so let's use a board game analogy here to unpack this. Say we're playing Monopoly, and the bank completely runs out of paper cash.
A classic Monopoly problem.
Right. But instead of stopping the game or, flipping the board over in frustration, we all just pull out a notepad. We agree to trade ledgers. So if I land on your property, I just write down the numbers and we zero out our accounts to keep the game moving. Is that it?
That captures the dynamic perfectly, yeah.
Yeah.
And if we carry that ledger analogy into a courtroom, it drastically changes the role of everyone in the room.
How so?
Well, in this post-1933 equity framework, a judge is not an all-powerful moral arbiter deciding right and wrong. The judge is fundamentally viewed as a banker.
A banker.
Yes. The courtroom is just a place of business, and the judge's only real job is to settle the book so everyone can balance their accounts and go home.
Okay, so if the courtroom is just a bank and the judge is just a teller, how do you actually make a deposit? I mean, if you don't have lawful money, what is the currency you're using to balance this ledger?
That is where Julian Swan introduces this concept of commercial honor.
Hmm.
And he actually traces this back to a highly specific piece of history, which is old maritime law, the law of the sea.
Oh, wow. Okay.
Yeah. Hundreds of years ago, if a ship captain sent a crew halfway around the world, the logistics were incredibly fragile. When that ship arrived at a distant port 6 months later, there had to be provisions waiting for them. Ropes, biscuits, butter, things like that.
And obviously there's no telegraph, there's no internet. You can't just wire money or send a quick email to negotiate prices before you arrive.
Exactly the problem. Because communication took months. If the crew arrived and didn't like the price the merchant was charging for those biscuits,
They couldn't exactly leave a one-star review.
no, they couldn't send a letter back home arguing about the cost. Arguing would stall the voyage, ruin the timeline, and literally threaten the survival of the crew. Right.
Therefore, in maritime commerce, it became a strict rule of honor to accept what was presented to you at face value without arguing. Accepting the ropes and biscuits without a fuss was considered honorable. Arguing over the price was dishonorable.
Which makes sense for, like, a 17th century galleon. But Swan is mapping this ancient maritime concept directly onto our modern legal system today.
He is, yeah.
He says that when you receive a charge today, so a credit card bill, a traffic ticket, a court summons, it is viewed as a commercial presentment.
And we can actually update the analogy for today to make it clearer. Think of a commercial presentment like receiving an expensive package from a FedEx delivery driver.
Huh.
The driver hands you the scanner. You have two choices. You can sign for it, taking responsibility for the package, or you can simply refuse delivery.
Right.
What you do not do is stand on your porch screaming at the delivery driver about the shipping costs or arguing that you didn't even order it.
Because the driver doesn't care. They just need a signature or a refusal to clear their own ledger. They're just doing their route. Precisely. According to the source, when you receive a legal or financial presentment, you have what Swan calls a liability to reply and a power to create discharge.
A liability to reply.
Yeah. If you argue, if you fight back, if you write an angry letter to the court saying, I don't owe this money, this ticket is bogus,
Right.
you are creating commercial dishonor. You are basically standing on the porch screaming at the FedEx guy.
Wow.
And the system actually thrives on that controversy. When you argue, you legitimize the fight, and you give them jurisdiction over you.
Hold on, though. Here's where it gets really counterintuitive. You're telling me this system wants you to get sued because the transcript repeatedly states this maxim of equity. The position of the defendant is preferred.
It'd say that.
That makes zero sense. Nobody wants to be a defendant. I mean, a tax lien or a lawsuit is terrifying. Why on earth is that the preferred position?
It's preferred because of how equity views power dynamics. Remember, it's all accounting in this framework. When you are the defendant, you didn't start the fight. Someone brought a charge, a bill, to you.
Okay, I'm tracking.
Therefore, you hold the power to act as the accounting defendant. You hold the power to discharge it. But, and this is a big but, you can only exercise that power if you stay in honor. And you stay in honor by using what the presenter calls the art of inquiry.
Wait, so you don't even mount a defense. You just play Jeopardy. Like everything has to be in the form of a question.
Essentially, yes. In this framework, you never testify. You never make a declarative statement.
Not even to say you're innocent.
Nope. If you make a statement like, I was not speeding, you now have the burden of proof. You have to prove it, which immediately creates controversy. And the court's entire purpose is to eliminate controversy.
Oh, I see.
So by only asking questions, you put facts on the record without ever actually testifying. You force the other side to trip over their own accounting errors while you just stand there calmly holding the ledger.
Can you give an example of what an equitable question actually sounds like? I mean, if I'm not saying I didn't do it, what am I asking?
A classic example in these types of frameworks would be responding to a charge by asking something like, could you please provide the sworn affidavit from an injured party who claims I breached a contract?
Interesting.
Right. You aren't denying the charge. You are simply asking for the underlying accounting documents that prove a loss occurred. Since many victimless crimes or standard regulatory tickets don't have an injured party, you are asking them to produce something they just can't.
Okay, well, if the strategy is just asking the right procedural questions, my first instinct would be to hire the smartest, most aggressive lawyer I can find to go ask those questions for me.
That makes sense.
But Swan argues that bringing traditional legal representation into a courtroom is literally the worst thing you can do. He says it completely defeats the purpose of equity.
He does. He claims that attorneys operate exclusively in what he calls a fiat fiction matrix. They are professionally trained to argue, which automatically puts you in commercial dishonor the second they open their mouths.
Just by talking.
Exactly. But the workshop goes even deeper into the very language used to define a lawyer. Swan points to the term attorney at law. He pulls out Black's Law Dictionary and notes that one of the legal definitions for the word at is near.
So they are attorneys near the law. They aren't actually in the law.
Yes. Furthermore, he argues they only represent legal fictions, not living beings. This ties into a concept really common in these alternative legal circles. It's often called the straw man.
Oh, the straw man.
Yeah, if you look at your driver's license, your credit card, or a court summons, your name is almost always printed in all capital letters.
Right, like John Doe in all caps.
Swan's framework posits that John Doe in all caps is not the living, breathing human listening to this deep dive right now. It is a corporate trust, a legal fiction created by the state at your birth.
Okay, so the lawyer only represents the fiction.
Exactly. An attorney, because they operate in the legal matrix, can only represent that all caps fiction. They are actually barred from bringing equity into the courtroom, because equity only acts upon actual living beings.
So to use this system, you literally have to fire your lawyer. You have to walk into the courtroom, which the transcript calls the place of judgment, entirely on your own.
Just you.
And according to Swan, you don't challenge jurisdiction, you don't argue venue, you don't file motions to dismiss, you just stand there in honor, and you compel performance by exposing what he calls the secret contracts running the court.
And we should definitely clarify what a secret contract means here. We aren't talking about a literal piece of paper hidden in a safe in the judge's chambers.
Right.
A secret contract, in this worldview, is the silent assumption of jurisdiction. By hiring a lawyer, by arguing, by stepping past the bar in the courtroom, you are silently consenting to play by their rules. You are entering into an unseen contract to let them judge you.
The workshop actually shares a really striking anecdote to illustrate what happens when you break that unseen contract. There's a story about a young man in Chicago, which the presenter refers to as the Chicago gun case.
Oh yeah, this is a powerful example.
It really is. So this young man gets caught with a firearm in Chicago, where the gun laws are incredibly strict. He's facing years in federal prison. But instead of letting a public defender argue his case and make a plea deal, he goes into court using this post-1933 equity process.
And the scene Swan describes is incredibly tense. It's a packed courtroom. The judge is yelling, running through the docket, handing out fines and jail time left and right, just totally in Matrix mode.
Right. And finally, the courtroom empties out, and it's just this young man left sitting there in the pews. He hasn't argued. He hasn't caused a scene.
He just waited in honor.
Exactly. And according to the source, the judge actually steps down off the bench. He walks across the empty courtroom, sits down next to this kid, puts his arm around him and says, "I know what you're trying to do. You're trying to bring equity to my court. Just take this gun class and this will all go away."
It's such a fascinating narrative because it illustrates the core synthesis of this entire strategy. As Swan puts it, equity makes you equal with the judge.
Equal with the judge.
Right. In a normal court proceeding, you are a subordinate. You are looking up at the bench, begging the court for leniency or arguing facts from a lower position. By stepping into equity, you refuse the subordinate role entirely.
You just level the playing field.
Yes. You don't argue the law. You address the commercial reality. You become an equal, demanding an accounting settlement. And in that anecdote, the judge recognizes that equality and simply settles the book to make the controversy disappear.
I have to admit, hearing that story, it sounds like a magic cheat code. Like a mechanical legal loophole where you just string the right magic words together and the matrix bends around you.
A lot of people approach it that way.
But Julian Swan is absolutely adamant that it is not a mechanical trick. In fact, he insists that if you treat it like a loophole to get away with something, it will fail completely.
Yeah, this is where the workshop shifts away from dry legal theory into something much more psychological and even spiritual.
Spiritual, right?
Yeah. There is a strict ethical requirement to all of this. It's encapsulated in a famous legal maxim. The presenter quotes, "He who comes in equity must come with clean hands."
Clean hands, meaning you can't be trying to scam the system.
Well, it goes much deeper than just avoiding fraud. You can't be angry. You can't be seeking vengeance. The source claims that equity doesn't just derive from old maritime law. It ultimately comes straight from a divine source. It requires a genuine heart of forgiveness.
Whoa, okay.
Yeah, if you walk into that courtroom holding on to bitterness, if you are secretly trying to use these questions to stick it to the judge or humiliate the prosecutor or get revenge on whoever sued you, you are automatically in commercial dishonor.
The workshop actually shared a highly emotional example of this from a student in Swan's class. It's a pretty tragic story. The student's husband died, and she firmly believed it was due to the hospital's protocols during the COVID pandemic.
Right.
She was devastated and, understandably, furious. She wanted to use the legal system to fight the hospital and make them pay for what happened.
Which is a situation where almost anyone would be entirely consumed by a desire for vengeance.
Exactly. But instead of hiring a malpractice lawyer and going to war, she applied the principles of equity. She found some old notes concerning her husband's care, and she described finding them as a spiritual presentment from God. Instead of using those documents to launch a massive lawsuit, she used the opportunity to begin the internal process of forgiveness. She accepted the presentment.
That is just an incredible psychological pivot. Swan explicitly warns his students against the alternative, which he calls mixing processes.
Mixing processes.
Yeah, because there is a massive subculture of alternative legal theories out there. Sovereign citizen methods, common law grand juries, people filing massive affidavits and liens against judges.
Oh, I've heard of that stuff. Paper terrorism?
Exactly. The presenter says if you try to mix those aggressive combative strategies with the peaceful inquiry of equity, you become what he calls double-minded.
Wait, the transcript mentioned something crazy happens when judges encounter this double-mindedness. Didn't he say they order psychological evaluations?
Yes, he did. And think about it from the court's perspective.
Okay.
You are standing there trying to act as a peaceful accounting defendant, using the high-minded language of equity and forgiveness. But simultaneously, you are throwing legal punches, filing aggressive paperwork, and projecting the energy of a war.
So the behavior is entirely contradictory.
Right. The court's reaction isn't just to rule against you. They assume you are fundamentally disconnected from reality.
Because you're speaking peace but acting out war.
Exactly. Swan stresses that complete, total commitment to peaceful inquiry and forgiveness is absolutely required to see what he calls the miracles of equity. You cannot fake clean hands. The judge, acting as the banker, will see right through it.
Look, whether you accept the post-1933 financial theories presented in this workshop or not, there is a massive psychological takeaway here for anyone listening. By refusing to play the victim, by actively choosing not to argue and choosing forgiveness instead, you take the emotional power back from whoever wronged you.
You really do.
You stop playing their game on their terms.
It is a radical reframing of the power dynamic between the individual and the state. Honor with Equity reveals a worldview that looks at the intimidating heavy machinery of the legal and financial worlds and sees something entirely different than the rest of us.
Yeah, they don't see fixed, immutable authorities waiting to crush them.
No, they see a fragile web of commercial contracts and accounting errors, and they believe that by stepping outside of the argument, by refusing to fight, and by balancing those ledgers through honor and inquiry, you can effectively make yourself untouchable.
As we wrap up this deep dive, there is one final, incredibly provocative thought from the source material that we need to leave you with. It's a concept the presenter mentions almost casually toward the end, but the implications of it are just staggering. He quotes a maxim that says, "Equity time travels."
It's a brilliant metaphor for the mechanics of this system, honestly. What he means is that equity has the power to go back and clean up past mistakes.
How does that work?
Let's say you have a legal charge, a bad foreclosure, or a massive debt that has been sitting on your record for 20 years. The source claims that once you learn this process of commercial honor, you can respond to that 20-year-old event today as if the envelope just arrived in the mail yesterday.
Equity time travels. I love that phrase. It raises a fascinating question about our own lives outside the courtroom, doesn't it?
It really does.
Think about the permanent records we all carry around in our heads. our financial debts, our past legal mistakes, the times we engaged in our own versions of commercial dishonor by fighting the system or acting out of anger and bitterness.
Right, the stuff that weighs us down.
We tend to view those things as permanent stains on who we are.
We treat them as absolute, unchangeable reality.
But what if those permanent records are only as permanent as our willingness to accept them as final? If a system or a mindset exists that allows you to retroactively correct the past just by fundamentally changing the way you respond to it today, does our history actually define us? Or is it all just an open ledger sitting on a desk waiting for you to walk up, pick up the pen, and ask the right question?